Madam Chairperson, Honorable Madam Justice Janet Cummings Edwards, Chancellor of the Judiciary, representative of the Honorable Minister of Human Services, Dr. Vindhya Prasad, Mr. Adam Lawyer, and other distinguished representatives of the Canadian High Commission, my Permanent Secretary and Deputy Permanent Secretary, our representatives of our important developmental partner, the IADB, representative of the Commissioner of Police, Mr. Calvin Rutas, the Director of Restorative Justice, and the former Director, and last but not least, you, the participants of this training exercise. I want to take this opportunity to reiterate the words of welcome already expressed by the speakers who spoke before me. And I want to also reiterate my deep gratitude to our Canadian colleagues who have so graciously volunteered to do this training exercise pro bono. We hope that this is going to be a continuous engagement where we will continue to benefit from the expertise of not only the Canadian government, but other governments across the globe. Restorative justice is now part of the permanent landscape of the administration of justice in Guyana. In 2022, we enacted in our Parliament the Restorative Justice Act. And by that measure, restorative justice is now firmly entrenched in our laws, in our regulatory framework, and in the administration of justice in our country. Restorative justice is one of the many concepts which we have incorporated into our justice system that demonstrates the government's commitment and the judiciary's commitment to ensure that our justice system continues to be dynamic and continues to incorporate the innovations, the new evolving concepts, and the new developmental trends taking place in other parts of the world, all in an effort to make our administration of justice that dynamic institution that can flex and remain flexible to the exigencies of a changing society. Like every other system, the administration of justice must be able to modify itself, must be able to innovate, must be able to reshape to meet the nuances and the emerging new behavioral patterns in a society, or else the society will go ahead and the administration of justice will remain behind, becoming an obsolete institution. And that's why we always have to keep enacting new laws and incorporating different concepts in the legal sector and indeed every sector in our country. So in the legal sector, alternative dispute mechanisms have now become a permanent part of the tapestry of this sector. So we have mediation by statute, we have arbitration, and to this end I have already laid in the National Assembly a new and modern arbitration act bill, which will become an act shortly, and that will change in a transformative way the arbitral and arbitration architecture of our country. Arbitration, another form of alternative dispute resolution, is one of the preferred modes of settling large commercial disputes. Our country's commercial sector is expanding like never before, and therefore we have to incorporate into our legal system and into our government structure new and innovative measures and mechanisms that will allow this growth and will conduce to this growth taking place. All the modern contracts that we are reading now have ensconced in them arbitration clauses, which take the arbitration to different parts of the world, metropolitan centers like New York, Canada, London, etc. Why? Because they feel that we don't have the statutory capability and we don't have the institutional capacity to do the arbitration here. Well, we would like to change that. And the first step is to get a modern arbitration act in place. And that's what we are working on. But that arbitration act is different from every other one that we have seen. Because this arbitration act that we will put in place in Guyana will not only allow arbitrations to take place in Guyana, but will allow for top-class arbitrators and companies offering arbitral services to come to Guyana and establish themselves. So if it is felt that we don't have the human services available here, well, the Act has the capability to allow for the importation of that quality service from wherever part of the world it is situated and bring it to Guyana. Another component of our administration of justice, we are revamping our plea bargaining legislation. And in the Parliament already, or about to be tabled in the Parliament, is a new plea bargaining bill. That's another form of alternative dispute resolution, this time in the criminal justice sector. That legislation will give both the defense, the accused person or the defendant, and the prosecutorial arm of the state tremendous leeway and latitude to sit at a table outside of a trial environment and to work out a plea deal that will satisfy the basic tenets of our community's sense of justice. I emphasize that point because we are a society that believes in strong punishment, and none of these measures are intended to dispense with strong punishment in appropriate cases. That is why when I get to restorative justice shortly, I will explain, and as in the plea bargaining legislation, there are certain categories of cases that will not be part of this process. Murder, capital offenses, offenses involving abuse of our children, sexual offenses, offenses dealing with trafficking in person, and violence are not subject to these processes. So the strong punishment that are deserving in those types of cases will remain intact. So I just want to make that point. So in the pre-bargaining, again, there is wide latitude to bring to an end without protracted trials and without huge resources being expended and time being expended. We can bring a large number of criminal cases to a just conclusion, and we can do so with great expediency. And that brings me now to restorative justice. And I give you that backdrop so that you appreciate that restorative justice is not a measure that is in isolation. It is one that complements a philosophy and a policy which we are implementing in our country. As you would have heard, restorative justice is yet but another mechanism being utilized across the globe by countries to address certain types of criminal offenses. My learned friend, my learned colleague, Magistrate Peter Yu is here with us, and he will confirm that perhaps 80% of the cases that go before him as a sitting magistrate are cases that are not the serious indictable cases to which the learned Chancellor made reference. They are minor offenses, and they would occupy 80% of his time, of his energy, and of his resources. Restorative justice can address most of this 80% workload that he faces as a magistrate every single day. And that is replicated in every magistrate court across the country. Imagine if we are able to entrench and interweave restorative justice in our criminal justice system in the institutional manner that we would like to, the tremendous positive impact it will have in reducing the workload of every single magistrate in this country. And that is the intention of our government. And restorative justice, quite apart from bringing that measure of speed and expediency to the system, has in it some innate benefits that are unique, because it strikes at, or rather it is directed at repairing that human relationship between the complainant and the defendant. In small communities like that which exist in our country, these are relationships that can date back to generations because of the close geographic proximity of a virtual complainant and a defendant in any given situation. Our country, as you know, is divided into magisterial districts. Each magisterial district consists of several villages. And who you think appear before the magistrate, 80% of the time, it is persons within one village that have problems with each other. It's only cases where traffic offenses, etc., that you find the police being the active initiator of the legal proceedings. In every other case almost, it's persons in the same locality having disputes and physical interaction with each other that lead to the institution of criminal charges. Restorative justice as a concept allows the practitioner to bring the complainant and the defendant together and try to repair that relationship. If that process is successful and that relationship is repaired, and animosity and antagonism and hate is replaced with brotherhood, with love, with affection, with respect, then the pool, the reservoir that leads to that constant fight or that constant confrontation will dissipate, and a problem perhaps can be, a perennial problem can be permanently solved. It allows also for the practitioner to delve deep into the root cause, because what goes before the court is simply a symptom. Restorative justice allows you to go to the cause, to interrogate that symptom, that manifestation, and get to the root and pull the problem from the root. The root cause may be an abusive childhood, an abusive home, or an abusive relationship. Restorative justice allows the practitioner to interrogate and go to that cause. And when that cause is found, to address that cause, address the disease, cure it, so that the symptom will not arise. And there are many, many other benefits that restorative justice allows. It allows for compensation. Many of these problems, again, the problems in the magistrate court are driven, as I said, by historical animosity. And if you bring these two parties together and monetary compensation becomes part of the equation, or even an apology can go a far way in addressing injured pride and a perceived injured dignity. These are little social concepts. Because they are left unaddressed in our conventional legal system, they continue to cause recidivism, the repetition of these offenses. Restorative justice addresses creates the platform for all these issues to be addressed. And that is why we have with us today the Chancellor of the Judiciary, we have a representative of the magistracy, we have a representative of the Commissioner of Police, because these are the main institutions, a representative from the Ministry of Human Services, because these are the main institutions that will be driving the restorative justice concept in our legal system. As the chairperson indicated, it's now part of the program of the Ministry of Legal Affairs. It was born out of an IDB project, and as of December last year, it was transitioned into the Ministry of Legal Affairs as part of our agenda, and we have received budgetary allocation for it and will continue to receive budgetary allocation for it. Thank you. We have now a center, and we are to staff that center adequately and with competent personnel. And I want to recognize the tremendous work that Mr. Silal Prasad has rendered to this institution and to the concept of restorative justice. He took it from the very, very early stages and walked it to where it is. And now we have Mr. Boston, who will take it over and grow it into the organization that we would like to see. Now, so we have a center in Georgetown that will be the head of what we plan to spread out across the country. At this stage, we don't have the resources to do that dissemination in the manner that we would have liked to. As a result, I have discussed with my colleague, Minister Dr. Vindhya Prasad, and we have agreed to use the probation department across the country and to install in the probation department across the country a restorative justice component, either one or two officers. Now, I have confirmed that we have probation offices in every administrative region in the country. And in some regions, we have more than one. So we already have, if we incorporate restorative justice into these probation departments, we have a location across the country. We already have, historically, a relationship between the administration of justice, the judiciary, and the magistracy, and the probation department, probation departments across the country. We are going to capitalize on that relationship. Magistrates and judges in the administration of criminal justice on a regular basis call upon the probation department for reports in order to assist them in coming to just decisions in the discharge of their functions. So there is that institutional relationship already existing. That is the relationship that we wish to capitalize on. So at the magistrate's court, it's my vision to see the probation officer sitting, and alongside him will sit the restorative justice officer. And those two persons will be in the magistrate's court every day across the country, or as the magistrates would recommend. So the two officers or the two services would be readily available to the magistrates and judges alike. And they are not unrelated. They complement each other. Because the probation department offers not only probation reports, but they offer all manner of other services, including counseling, etc. And it is that kind of setting that is conducive for a restorative justice practitioner to be able to discharge his responsibility. And more so in this unique environment in tandem with a probation officer. So that is why these two services are being twinned across the country. We have already trained a number of persons already across the country, and this is another set of trainings that we will embark upon. I understand that after this, there is still yet going to be other sets of training. So we will continue to train people, even if you are incorporated formally in the system or not. Your knowledge of restorative justice will serve you well in your community. We have chosen in every community leaders or persons who are perceived to be influential in these communities. So we have trained all the two shalls, this current set and many others before. In almost all the regions, or most of the regions, we have trained the religious leaders and other persons considered influential and leadership materials in those regions. We have trained school teachers and public officers across the public sector apparatus, because these are all important practitioners, whether in the formal restorative justice program or in their peculiar institution. Because as I said, we want restorative justice to start in the schools. Because many of the problems, the symptoms of which manifest themselves by producing a defendant in a magistrate's court, start even early in the embryonic stages of the child, in the schools system itself. And we all live in this country, we see what is taking place in our school system. I see some horrible fighting scenes on the social media of photographs taken in schools with students and so on. So we have those challenges. Teachers will be best positioned if they are all part of this restorative justice education and training exercise. So I want to conclude my remarks by assuring you that restorative justice is here to stay. It is now part of our justice institution and part of our legal and social sector, and you are part of the history-making process of being among the first set of practitioners who are going to be trained and will be installed in the system across the country. I want to thank again our Canadian counterparts. I want to thank the IADB. I want to thank the police force. I want to thank the judiciary, and I want to thank the Ministry of Human Services for the cooperation that they have thus far rendered to us. And I want to say to them that the success of this program depends largely upon their continuous support. I want to take this opportunity to wish you all the best in your training, and hopefully you will continue to be part of our vision of making restorative justice a permanent institution in our country. Thank you very much.